Article 107 of the Constitution requires that an address be passed in the Parliament urging the President for the removal of a judge, if so required. The so-called address was taken up for debate in the Parliament. At the 11th hour, an opposition member took up the objection, stating that what was there on the order paper was not an address to seeking the removal of a judge, but for the appointment of a select committee. The Speaker adjourned Parliament for half an hour and came back and then made a ruling saying that they have gone too far, but proceeded to take the vote. They voted on what was there on the order paper, that was for the appointment of a select committee. That had nothing to do with the removal of a judge. But the very next day, the President removed the Chief Justice 43rd from office, and a new appointee was appointed. Police and hoodlums were there, and they invaded the Supreme Court complex the very next day. This is the plight of the rule of law and the administration of justice, and justice that is meted out to justices of the Supreme Court. The court premises wherever in the world are the symbol of people's freedom. The executive must not be allowed to extend its armed fist and tread there with police boots. The last BSL election took place shortly after the purported removal of the 43rd Chief Justice of Sri Lanka in procedures, which the bar rightly saw as a violation of the norms of fair trial that we all cherish in each day of our lives. In our professional work, we try to guarantee this right of a fair trial to our clients, whatever their social or economic status and standing. If we lose our struggle for professional integrity, if we cannot defend our right to practice our profession with dignity and independence on the basis of the highest principles on which the profession is founded, then every person who seeks justice will be at risk. Where the judiciary is concerned, appointments to vacancies are kept pending in Sri Lanka as a matter of course at the whim and fancy of the executive. This is not a healthy situation. Judges must be given security of tenure. There must be independent procedures put in place for their appointment and removal, and they must be financially secure. However, the obnoxious practice of conferring privileged positions on judicial officers after retirement at the discretion of the executive goes on with no hindrance. I'm sure you too are experiencing such situations in your country. This compromises the integrity of the judiciary without a doubt. Equally affected are those institutions which are more directly linked to law enforcement and the administration of justice, namely the Attorney General's Department and the police. Both police and law enforcement systems and the Aegis Department have faced serious problems due to politicization. President of the Court of Appeal, Justice Sri Skandaraja, who issued the writ on the Parliamentary Select Committee, was overlooked on 5 occasions for his due promotion to the Supreme Court. This happened nearly 1 year ago. While serving on the bench, he succumbed to his death after he suffered a stroke. Because he presided the bench that issued the writ of Parliamentary Select Committee that was appointed to impeach the 43rd Chief Justice, he was deprived of his due promotion. In the recent past, again the Court of Appeal presidency became vacant. A person from the Attorney General's Department has been just appointed, who has been just appointed as Additional Solicitor General in the Aegis Department. He is the 9th junior person in the department. The senior most judge of the Court of Appeal, another judge of that same divisional bench, has been deprived of his post again. He was Additional Solicitor General in the year 2005, and he was appointed as ordinary judge of the Court of Appeal, comprising of only 11, and he has had 7 years of judicial experience, but he has been overlooked. I will give you just an example as to what's going on right there at the moment. There was a case that was filed by, right at the moment there is another election in a provincial council called UWA. The election commissioner has ruled that the government effort through the Ministry of Economic Development to distribute 2,500 rupees in this area where the election is being held should be withheld until such time the election is over. Election will be held 1 week ahead, in just 1 week, on the 20th. Anonymous person, unknown person has gone to court yesterday, and the matter was taken up as last matter, and the Ministry Secretary or the Ministry of Economic Development, not the Disaster Management Development Ministry, if at all it should be attended to by the Disaster Management Ministry. The Ministry Secretary was waiting from morning till evening. The State Counsel who appeared for the Attorney General's Department informed court that the Election Commission has made a ruling on this basis that not to do it during the time pendency of election. This was ignored, and an order was made permitting the distribution of 2,500 rupees per household immediately, and the matter was concluded. It is a responsibility of the legal fraternity world over to collectively strive to remedy this crisis of confidence. More importantly, the principle of equality before law is being increasingly undermined in Sri Lanka. Public cynicism is widespread in regard to the manner in which this principle has been ignored. There is impunity for politically influential persons who openly violate the law. Others who may under normal circumstances not be penalized are being summarily, arbitrarily punished. We are aware that in several countries where the rule of law has been undermined, litigation has been reduced to many forms of bargaining. In fact, often it is nothing more than bargaining. Legal texts and judgments are of little relevance. The above issues I have raised are relevant in deciding the kind of bar that we want in Sri Lanka. They are the same principles upon which you decide upon yourself as to the bar and the judiciary that you want in this great country of yours, India. We must not let the great expectations of the legal fraternity to succumb to compromise, capitulation, and finally utter ignominy. As has been phrased in one such relevant criticism, we must work in solidarity with legal fraternity within this global village. The integrity and independence of the legal systems and the judicial institutions and the very law itself cannot be of concern only to judges and lawyers. Rather, it is of paramount concern to each and every one of us in the Commonwealth and the rest of the world. We urge you to express solidarity with us in our struggle to protect the dignity and independence of the judiciary and the legal profession. The Bar Association of Sri Lanka needs to work in close association with our colleagues in other countries, particularly India. As the President of the Bar Association of Sri Lanka, I have shared these thoughts with you because it is essential for us to appreciate that we are a profession that has many promises to keep. We will not betray those promises. Having assumed the office of the BSL presidency, my endeavor has been to harness the support collectively from all members of the bar, locally and internationally. I will briefly explain one incident that I have been going through that would assist you to understand the kind of pressure that we have been subjected to. With regard to the appointment of judges, we have taken up these issues even before the apex court itself, before ceremonial sittings. We have blamed the executive in no uncertain terms. We have also, it is customarily the President of the Bar Association and the Attorney General are the only two people who speak at a ceremonial sitting when held to welcome a judge. When the last three judges were appointed, I welcomed the first judge very warmly because that was a rightful appointment. The second judge had a fair amount of problems. I welcomed him. The third judge did not belong to the category time-tested criteria of eminency and in legal submissions as a lawyer. He was from the unofficial bar. I did not welcome him at all. But I also did not mince my words to blame not only the executive, but also those who cringe and scrounge and fall at the feet of the executive, seeking appointments that do not legitimately belong to them that made the present Chief Justice and several others on the ceremonial court bench consisting of nearly 45 judges squirm in their seats that they were holding to. Let me finally conclude with a quotation from Rabindranath Tagore. Let me not pray to be sheltered from dangers, but to be fearless in facing them. Let me not beg for the stilling of my pain, but for the heart to conquer it. Let me not look for the allies in life's battlefield, but to my own strength. Having said that, I will just briefly tell you what I had to undergo and the price that I have been called upon to pay. This happened on the 15th of July. I had to make a complaint to the police when I saw two men on a motorcycle was trailing behind me, and they were joined by another two people on a three-wheeler. This was brought to the notice of the police, and the police took all the video footage from the beginning to the end, and they found that they confirmed that I have been followed by these men on the motorcycle and the three-wheeler. The question was asked by the leader of the opposition in the parliament. The Prime Minister confirmed that the incident is true. I sought for security. Sorry, I did not seek for security. The Executive Committee of the Bar Association went to court and sought security to be provided for the President of the Bar Association. That was turned down. This is the situation that we go through, but we are ready for this. We are ready for the struggle. As your President, Mr. Anil Divan, said that in the morning, we shall never rest. We shall continue with our struggle, but we urge that you, in this jurisdiction, great many lawyers, jurists, and people who have made so much of contribution to the development of law and the independence of the judiciary, join with us in our struggle to seek a greener pasture and for the benefit of the people of our country and the judiciary and the bar. I'm very much thankful to the invitation that has been afforded to me by Mr. Prashant Kumar, and I must say, I must confess that I have enjoyed every minute of this association from morning till now, and thank you very much.
Friends, I didn't know all the details, but it reminds me of our emergency, 1975 June to March 1977, where most of you, the younger people, may not have been born. 1975 to 77. All the opposition leaders were in preventive detention, including Morarji Desai, Vajpayee, Advani, and of course, Jayaprakash Narayan. Please, please. So I'm reminded of that, and I'm amazed at the valor and the spirit of the Sri Lankan bar. We heartily not only appreciate but admire your efforts, and whatever little we can do from here, we will try and do it. But the problem is this: your political executive has come on a wave of popularity after the LTTE incidents, because people were fed up of violence, it seems. And because the LTTE menace has gone, there's an enormous popularity wave by which these dictatorial powers seem to have been concentrated in the President and his coterie. Now I'm sure with the passage of time, things will die down a little. But I must congratulate you at the spirit which you have shown, and all our good wishes will be always with you. Friends, the next speaker is Prashant Bhushan, who does not need an introduction in India, because most of the time in the evening he's on the one channel or the other. But I must share with you what an English critic said. He described the Official Secrets Act, the Official Secrets Act. It's in England and also in India. So what is the object and purpose of the Official Secrets Act? The object is not to protect secrets. The object is to protect officials. Huh? But there is no secret from Prashant Bhushan as far as either government or officials are concerned. He can unravel any secrets. So Prashant, would you please, as a one-man army in the PIL, share your thoughts with us?
Thank you, Mr. Divan. Friends, ladies and gentlemen, after hearing this rather very disturbing story about Sri Lanka and the state of the independence of judiciary in Sri Lanka from Mr. Jayasuriya, I feel that those kind of problems in India are virtually non-existent. However, there are problems even in India. When we talk of independence of judiciary, what do we mean by independence of judiciary? Independence literally means independence from any kind of extraneous influence. Traditionally, however, we have come to understand independence of judiciary to mean independence from government influence, which is actually in many ways the most important aspect of independence of judiciary, because one of the increasingly important roles of the judiciary is not merely to administer justice between citizens and citizens, but rather to ensure the rule of law, to ensure that citizens' fundamental rights are protected, and to ensure that the executive and the legislature not only perform within their constitutional limits, but also that the executive does its constitutional duty when it is required to do so. Because every power is coupled with a duty, and if there is a power in which the executive can exercise and should be exercising, and it still does not exercise it, it is the role of the judiciary to ensure that those powers are exercised in public interest. So that is why, because of this role of the judiciary to keep the executive and the legislature in check and to ensure that they perform their functions, which has become an increasingly important role of the judiciary, especially in the era of public interest litigation, that is why independence of the judiciary from the government or from the executive and the legislature has assumed such great importance that today, when we talk of independence of the judiciary, we effectively mean independence of the judiciary from the executive and the legislature. However, independence does not mean independence from accountability. Unfortunately, some people in the judiciary especially, when they start talking about independence of the judiciary, they start extending this concept of independence to mean independence from all kinds of accountability. And it is somewhat in that sense that the judgment in Veeraswamy's case was rendered, by which the Supreme Court held that even before registering an FIR against any judge, you have to take the written permission of the Chief Justice of India. Because one of the problems today, in fact, you see, independence of the judiciary from extraneous influences would ipso facto require proper systems of accountability for the judiciary. Because how do you ensure that the judges do not get influenced by other extraneous considerations such as monetary considerations, other conflicts of interests, etc.? The only way to ensure that is to have a robust system of judicial accountability. Unfortunately, in India, we do not have those. And that has become a source of serious problem because of which we are not able to ensure independence of the judiciary from other kinds of extraneous influences. Because today there is no system of any kind of disciplinary control over the judiciary. Of course, the government should not have disciplinary control because that will compromise the judiciary's independence vis-a-vis the government. But we certainly need some authority to whom people can go, some independent authority, we can call it a judicial complaints commission or whatever, to whom people can complain about misconduct, corruption, conflicts of interest in the judiciary. Unfortunately, we don't have any such mechanism. The only system is of impeachment, which we have seen is impractical and has failed, because even in order to start any impeachment, you need signatures of 100 MPs, which is virtually impossible to get. Secondly, we have this antiquated Contempt of Courts Act. Now, contempt means three things: civil contempt,